Yes.
Sir, you have a right to have a probable cause conference within 14 days of this arraignment, and you also have a right to have a preliminary exam within 7 days of that conference. A preliminary exam is a probable cause hearing where the prosecutor must show probable cause that a crime was committed in Livingston County and also show probable cause to believe you're the one that committed that crime. Do you understand that right, Mr. Carrier?
Yes.
Very good. Do you have the dates of those on the ROA?
Yes, the probable cause conference will be July 26, 2017, and the preliminary exam will be August 2nd, 2017.
Mr. Carrier, you're also entitled to have an attorney, sir. You can either retain your own attorney at your expense, or I can appoint you an attorney through the court. What would you like me to do today, sir?
I believe I have an attorney, but I'm not for sure yet.
Okay. Well, when you find out, please notify the court whether you have counsel or not. Otherwise, we can make sure you have counsel, okay?
Okay.
Mr. Carrier, once you have that attorney, you have a right to have that attorney present for any questioning you consent to. You also have a right to have that attorney represent you at all subsequent court proceedings. You do enjoy the right to remain silent, but anything you say orally or in writing can be used against you in court. Do you understand those rights, sir?
Yes, sir.
Very good. At this time, I'm going to allow Mr. Valancourt, on behalf of the people, to allocute for the people.
Thank you, Your Honor. At this time, the people are asking that you hold the defendant without bond. Under MCR 6.106, you are allowed to hold a defendant without bond when he's charged with murder, which the defendant is charged with 5 counts of murder in this case, and if you find that the proof of the defendant's guilt is evidence. I would submit to the court that the proof of the defendant's guilt is evidence in this case. His blood alcohol content was well in excess of the legal limit. He was driving at a speed approaching 100 miles an hour. Before this incident, he was questioned about whether he was too drunk to drive. He was told not to drive, but he acknowledged driving and continued to do so. In fact, the defendant later told police, "That was my choice before I got in the car." So under the circumstances, I think that the proof of the defendant's guilt is evident and justifies a denial of bond. His prior record includes, for alcohol convictions, a 2013 conviction for minor in possession of alcohol, a 2014 conviction in Genesee County for operating while impaired, and then a 2016 conviction for minor in possession of alcohol. His license was suspended indefinitely by the Secretary of State on September 28th of 2016, plus he had additional suspensions for failing to answer citations that were entered by the Secretary of State in March of 2017. So in light of all these circumstances, I would ask the court to deny him bond. If the court is, however, inclined to set bond, I'd like the opportunity to speak to conditions that could be set for that.
Very good. Thank you, Mr. Valancourt. Were you able to hear that, Mr. Carrier?
Yeah, I was able to hear that.
Okay, very good. There's opinion at the court at this time that based on the facts and circumstances of this case and the allocution of the prosecutor on behalf of the people, that I'm going to deny you bond at this time. Thank you, Mr. Carrier. That concludes this arraignment.
Thank you, sir.
You're welcome, Mr. Valancourt.